I'm Greg Demopoulos. I've been an attorney in Michigan since 1988. The topic of this video is getting your driver's license back following multiple drunk drivings. I want to indicate to you first that this is for informational purposes. The facts of your case might be unique and there's no attorney-client relationship that's created by virtue of this video. In Michigan, if you have 2 drunk drivings or more within a 7-year period of time, the Secretary of State is going to take your driver's license away indefinitely. For 2 drunk drivings within 7, there's a 1-year period of time before you can ask the Secretary of State or Driver's License Appeal Division to get your license back. If you have more than that, then it's even more time. What I want to tell you is these license appeals are tricky. You definitely want to get a lawyer. I'll give you an example. The last data I have shows that there were 10,925 appeals for what's called a habitual offender. That's where you have 2 or more drunk drivings. Of those appeals, 5,300 people were denied at their hearing with the Secretary of State. So that's about 50%. Now, I can tell you that those people were probably meaning well and wanted to get their license back, but you're playing by the Secretary of State's rules. And I'll give you a very common example of where someone could get in trouble with their driver's license appeal. If you're in your appeal hearing and the hearing officer says, "Do you have an alcohol problem?" a lot of people are automatically going to say no because they think they're not going to get their license back. But if you think about the scheme, the statutory scheme that the Secretary of State has to use, you need to answer that question, yes, that you do have an alcohol problem. Here's the reason why. The law says you're a habitual offender and that you do have an alcohol problem. So if you deny that, you're not even getting past first base in your driver's license appeal. That's just an example. Now, to prepare for your driver's license appeal, you need a minimum of 2 things. You need a driver's license assessment by a licensed alcohol evaluator and or substance abuse counselor. You also need to have a 10-panel drug test along with that evaluation. The other thing you need is 3 to 6 letters which we call community proof letters. It should be from a cross-section of the community. I generally recommend 2 family members, 2 friends, and 2 co-workers. Where some people get tripped up on this is their letters are incomplete, and there are 10 things that have to accompany each letter. The first is they have to be signed and dated. The author's address and date-time telephone number has to be on the letter. The relationship of the author to you, how long this person has known you, how often the person sees you, where the person sees you, what the person knows about your past and current use of alcohol or drugs, when the person last saw or knew you had been drinking or using drugs, what the person knows about your past or current treatment or attendance at a support group, and any other important information about your recovery. If your letters lack any one of those, the hearing officers of the Secretary of State might not even consider the letter. Oftentimes, people think that they have to go to AA to get their driver's license back. That's not always the case. AA is great and it helps a lot of people, but if you have not been going to AA and you've been waiting for a couple years to get your driver's license back, it might not make any sense to just start going now because you have your driver's license appeal. That's a decision that you should make with your attorney and with your alcohol evaluator. So this is just some basic information I provided you. If you were to hire me to help you with your driver's license appeal, I do 3 things. I meet with you initially and get you in the right frame of mind as to what is expected of you at your driver's license appeal. Then we get the alcohol evaluation and your community proof letters. I review those to make sure we're not going to have any problems. A week before your hearing at the Secretary of State, you would come to my office and we would have a mock hearing, and you would be totally prepared for your hearing with the hearing officer. Then I would attend the hearing with you and present evidence on your behalf. Now, I've gone over the statistics of about 50% denial rate. What I find is my clients who come in here, we prepare, we have a mock hearing, and they listen to my advice, have a success rate of better than 90%. The problem with going to the Secretary of State and losing is you have to wait another year before you can go back. There is an opportunity for you to appeal to circuit court, but the burden of proof on an appeal to circuit court is oftentimes difficult to establish. So your best bet really is to put on a good appeal and to get a decision at the Secretary of State hearing level. If you have any questions, you can call me at 734-844-1400.